Bismillahirrahmanirrahim. Assalamu alaikum. This is the second lecture on legal procedure. The procedure adopted before the court for the purpose of justice. Summon, subpoena. SUBPOENA. B is silent. A के बाद B. B is silent. So subpoena or summon. So this is an order issued by the court for appearance of a person before the court on a certain date and time. So in Urdu it is Adalati Bulawa. Here a person is called by the court to appear before the court on certain date and time. And next is the warrant. Warrant is next stage of summon. If a person fails to attend the court after the summons being duly served to him, he remain absent from the court without any lawful excuse, then the court will issue the warrant. So warrant, again, it is a written order issued by the court for a person to appear before the court under penalty. So here there is the person is required to appear before the court under penalty. So this is the second step of the summon. If a person fails to appear before the court after noting down the summons without any lawful excuse, then the warrant of arrest are issued by the court. It is the written, sealed, signed order by the court served to a person under penalty for his appearance, for his forceful appearance before the court. So here it is under penalty, or he is bound. He is made bound to appear before the court. Types of warrant. Bailable warrant. Qable Zamanat warrant. Qable Zamanat warrant. It is temporary release of a person by providing surety for his or her later appearance before the court. So temporary release of a person by providing surety for his or her later appearance before the court. When this bailable warrant are issued, these are issued under penalty, and another person take the responsibility, a respectable person takes the responsibility that this person upon whom the warrant is served, this person will appear before the court on certain date and time. So this is the bailable warrant. Bailable warrant में ये होता है कि कोई और respectable person ये जिम्मेदारी लेता है कि ये बंदा डेफिनेटली फ़लाँ डेट के ऊपर इसमें अदालत में ज़रूर अपीयर होगा, मैं इसकी ज़िम्मेदारी लेता हूँ. तो श्योरिटी जो है ना वो दी जाती है इसमें बेलेबल में. सो बेलेबल वारंट where a person, a respectable person, takes the responsibility that so and so person will appear before the court on certain date and time is the bailable warrant. Qable Zamanat warrant. Non-bailable warrant. Non-bailable warrant. Here the person is, no bail is there, कोई ज़मानत नहीं है. The person is straightforwardly arrested by the police and remain under custody by the police, under custody of the police, and then on certain date and time specified on the warrant, this person is presented before the court by the police. So in non-bailable warrant, naqable zamanat warrant, here the police arrest the person. The person is kept under custody of the police till the person is presented before the court on the specified date and time. This is the non-bailable warrant. काबिल ज़मानत वारंट और नाकाबिल ज़मानत वारंट. काबिल ज़मानत वारंट वो है जिसमें कोई और बंदा ये ज़िम्मेदारी लेता है कि मैं ज़िम्मेदार हूँ, ये बंदा फ़लाँ एंड फ़लाँ डेट के ऊपर आपके जो है फ़लाँ अदालत में ज़रूर पेश होगा, तो ये बेलेबल हैं. नॉन बेलेबल वारंट वो होते हैं जिसमें पुलिस स्ट्रेट फॉरवर्डली बंदे को गिरफ़्तार करती है, अपने पास रखती है और उस डेट के ऊपर जो वारंट में मेंशन की गई है उसमें उसको अदालत के सामने पेश कर देती है. देन द विटनेस. Witness is a person who testifies the facts before the court. The definition of witness, gawah. In Urdu, it is gawah. The witness is a person who testifies the facts before the court is called witness. Types of witness, this summon, warrant, witness, all are the university notes, theory notes. Types of witness, three types of witness. Common witness. Common witness, it is an ordinary person who testify the facts before the court. An ordinary person, एक आम आदमी जो है वो अदालत के सामने जो वो जाता है और जाके वो बयान करता है जो कुछ उसने देखा, जो वो जानता है, तो ये एक कॉमन विटनेस है. इसको कहते हैं आम जो है वो गवाह है. और नेक्स्ट इज़ द एक्सपर्ट विटनेस. Expert witness is that witness who is expert of some field, as ballistic experts, the expert of the firearms. फायर का जो एक्सपर्ट है वो बैलिस्टिक एक्सपर्ट कहलाता है. सेम वे हैंड राइटिंग एक्सपर्ट, हैंड राइटिंग एक्सपर्ट, it is also expert witness. Doctor is also is expert witness. So the expert witness, the witness who can draw inference from the facts, is the expert witness. As there is a red spot on the shirt of a person. Now a common man will say there was a red spot on the shirt of so and so person. Now he cannot say the origin of that spot. The spot may be of blood, may be of paint, or any red color spot is there. So the expert will say that whether this spot is of blood origin or not. So expert witness can draw inference from the facts. Expert witness draw inference from the facts. Hostile witness. Hostile witness, the witness who makes purposefully makes wrong statements before the court. जो बंदा हलफ लेने के बाद, जो गवाह हलफ लेने के बाद अदालत में झूठ बोलता है उसको hostile witness कहते हैं. The person who after taking the oath makes willingly wrong statement before the court is the hostile witness. So three types of witness: common witness, expert witness, and hostile witness. Common witness is an ordinary person who testifies the facts before the court. Expert witness, this person is expert in some field, as a doctor is expert witness, as a firearm expert is expert witness. Then the handwriting expert is the expert witness. He is expert in some field and he can draw the inference फ्राम द फैक्ट्स, वो ये कह सकता है कि जो रेड कलर का इधर स्पॉट था वो ब्लड था या नहीं था. देन द होस्टाइल विटनेस, जो अदालत के सामने हलफ लेने के बाद झूठ बोलता है, द पर्सन हु आफ्टर टेकिंग द ओथ willfully makes wrong statement before the court is the hostile witness. Now the question is, a doctor is of what kind of expert? Ordinarily, most of the cases, the doctor is an expert witness. Ordinarily and in most of the cases, the doctor is expert witness, but he may be a common witness, as he is going there and he sees some incidents occurring before him, then he will become a common witness. So a doctor may be expert witness, he may appear before the court as a common witness. जैसे उसके सामने कोई लड़ाई झगड़ा हुआ है तो वो आम जो है ना बंदे की हैसियत से, कॉमन विटनेस की हैसियत से अदालत में पेश हो सकता है. एंड नंबर 3, डॉक्टर मे बी ए होस्टाइल विटनेस. इट इज़ ऑल्सो पॉसिबल दैट ए डॉक्टर मे टेल लाई बिफोर द कोर्ट. सो ordinarily the doctor is in most of the cases expert witness, but he may be a common witness and even he may be a hostile witness. Perjury. Perjury is a university note. A witness, this relates to the hostile witness. A witness who, after taking oath, willfully makes false statement before the court is guilty of crime of perjury. So a witness, कोई गवाह जो हलफ लेने के बाद जो है वो अदालत के सामने झूठ बोलता है, वो जो है ये अमल है परजरी. So a hostile witness is the culprit of perjury. A hostile witness is the culprit of perjury. He has made willfully wrong statement before the court. So a hostile witness and perjury is the same. The hostile witness is a culprit of perjury. He has made the wrong statements before the court. So perjury, a witness who after taking oath willfully makes false statement before the court is guilty of perjury. सो जो होस्टाइल विटनेस है वो गलत बयानी करता है अदालत में हलफ लेने के बाद, तो कहते हैं ये परजरी का मुजरिम है. एविडेंस, गवाही. एविडेंस, गवाही, एक्ट्स एंड फैक्ट्स हेल्पफुल इन ए केस अंडर डिस्कशन. Acts and facts which are helpful in a case under discussion. So these are the acts, these are the facts which are helpful in a case which is under discussion, under trial in a court, is the evidence. Types of evidence. Types of evidence. Oral evidence. Oral evidence means the person describes orally in a witness box, in the witness box which is on the left side of the court. In a witness box he described the whole story, what he has saw about this incident and what he knows about that incident is described verbally by the witness, is the oral witness, oral evidence. Next is the documentary evidence. Documentary evidence, documents means any piece of paper containing some information is called a document. Any piece of paper containing some information is called a document. So documentary evidence, evidence on the paper. Documentary evidence, evidence on the document. Evidence on the paper. Documentary evidence, any paper containing some information is a document, so any information on a paper is the documentary evidence. Then the circumstantial evidence. Circumstantial evidence, the evidence from which an inference may be drawn. Evidence from which an inference may be drawn. वो एविडेंस जिससे कोई नतीजा अखज़ किया जा सके is called the circumstantial evidence. Circumstantial evidence, the evidence from which an inference may be drawn. As you are going on a road, you see a dead body is lying on the side of the road. There are broken pieces of windscreen of a vehicle on the road. Broken pieces of windscreen are present on the road. There are also tire marks on the road as some person has tried to apply the brakes, and the tire marks are present on the road. So these are the evidences. Now from these evidence it is quite clear that it is a case of accident, roadside accident, and it is also called hit and run injury. The person after hitting the driver after hitting the person run away along with the vehicle. Hit and run injury, you know your knowledge from the roadside accidents. So circumstantial evidence, these are the evidences from which an inference may be drawn. आप जा रहे हैं साइड गाड़ी सड़क के किनारे एक डेड बॉडी पड़ी हुई है, वहाँ आपने देखते हैं कि विंड स्क्रीन के किसी व्हीकल की विंड स्क्रीन के टूटे हुए टुकड़े पड़े हुए हैं, और जो है वो टायर मार्क जो हैं वो सड़क के ऊपर मौजूद हैं, ऐसे जैसे किसी ने ब्रेक्स लगाई हैं. तो इन तमाम चीज़ों से इनफिर हम ये ड्रा कर सकते हैं कि ये एक रोड साइड एक्सीडेंट का केस है. दिस इज़ कॉल्ड द circumstantial evidence, the evidence from which an inference may be drawn. Next, fourth type, direct evidence and indirect evidence. Direct evidence is the evidence, it is the eyewitness, the person himself know all the facts about the case. He is an eyewitness of an incident. He himself has saw an incident occurring. So it is a direct evidence. जैसे आंखों देखा जो है ना, उसने खुद अपनी आंखों से वो वाक़या होते हुए देखा है, तो that is the direct evidence. The direct evidence, the person is eyewitness of that incident. Next is the opposite to the direct evidence is the hearsay evidence. Hearsay evidence means suni sunai baat. The person has no direct knowledge of the incidents. He has heard it from some other person. जैसे ये एक बंदा है, उसने डायरेक्ट नहीं देखा कि इंसिडेंट्स हुआ है, क्या हुआ है, उसने ये जो वाक़या है ये किसी और बंदे से सुना है, तो उसको कहते हैं इट इज़ हियरसे एविडेंस, सुनी सुनाई गवाही. एक डायरेक्ट विटनेस है जिसने अपने आई से सब कुछ देखा है, आई विटनेस है उसने खुद देखा है, डायरेक्ट विटनेस. एक इनडायरेक्ट विटनेस है, उसको हियर से एविडेंस, हियर से विटनेस भी कहते हैं, हियर से एविडेंस भी कहते हैं. तो वो एविडेंस जिसमें बंदा डायरेक्टली उस वाक़े को नहीं देखा, लेकिन ये चीज़ उसने किसी और से सुनी है, कहीं और से सुनी है, तो उसको कहते हैं हियर से एविडेंस, सुनी सुनाई गवाही. नाउ the question is whether hearsay evidence is admissible before the court. क्या सुनी सुनाई बात जो है वो एविडेंस के तौर के ऊपर अदालत में पेश की जा सकती है या अदालत इसको तस्लीम कर लेती है. Ordinarily hearsay evidence is not admissible before the court. अदालत hearsay evidence को नहीं सुनेगी और आम तौर के ऊपर, अमूमी तौर के ऊपर. बट इन सर्टन केसेस एस a doctor which has conducted the postmortem, who has conducted the postmortem, who has done the medical legal work, who has issued a medical legal report. Now, suppose he is dead, he is no more, or he has gone in any foreign country and it is not possible to call back him by the court. So, is in that circumstances, in that special circumstances, the hearsay evidence is admissible before the court. So ordinarily, a hearsay evidence is not admissible before the court, but under certain conditions, as a doctor will come to the court and doctor will certify that this postmortem report, this medical legal report is issued by me. But now here the doctor is not present. He may died some time ago, or he has gone to foreign country and it is not possible for the court to call him back. Now, in that case, a dispenser or any person working with him on that time will appear before the court and will certify that this medical legal or this postmortem report was issued by that and that doctor. So in that case, in certain cases, it may be admissible before the court. So oral evidence, the person himself describe what he has seen. Then documentary evidence, evidence on a piece of paper. Circumstantial evidence, the evidence from which an inference can be drawn. And then the direct evidence, eyewitness, hearsay evidence. He has no direct knowledge of that incident, but he has heard it from other person, hearsay evidence. So these are the types of evidence. Next is the oath. This is a actually legal definition of oath. The word oath includes a solemn affirmation substituted by law for an oath, and any declaration required or authorized by law to be made before a public servant or to be used for the purpose of proof whether in a court of justice or not. The person, this oath is not taken on any holy book. In some books, it is written that the oath is taken on the Holy Quran or on the Granth from the Sikh community or from the Hindus on the Gita. No, no holy book or no book is involved in oath. Only the person raise his right hand above the shoulder like this, and he will speak as, I will speak the truth, the only truth and nothing but the truth. मैं सिर्फ सच कहूँगा, मैं सच कहूँगा, सिर्फ सच कहूँगा और सच के अलावा कुछ ना कहूँगा. ये उसकी वर्डिंग है. इसमें किसी किस्म की हॉली बुक इन्वॉल्व नहीं होती. ये सिर्फ ये ना राइट हैंड आपने अपने कंधे के ऊपर ऐसे करना है और ये कहना है बिफोर द कोर्ट that I will speak the truth, the only truth and nothing but the truth. So मैं सच बोलूँगा, सिर्फ सच बोलूँगा और सच के अलावा कुछ ना बोलूँगा. These are the wording of the oath. Oral evidence, evidence, verbal evidence. Oral evidence, verbal evidence. The witness appears before the court to submit his evidence. Oral evidence, he stands on the left side, as you already know. So it is divided into three stages of this oral evidence. Examination in chief. The examination in chief, in this the person will describe whole the story, what he has seen and what he knows about the incident. Here this this oral evidence examination chief is done by the party who has brought the witness for this evidence. So here the person will describe all the story, what he knows and what he saw about the story, about the incidents. Next stage, second stage is the cross examination. इसको कहते हैं जिरा. This cross examination is done by the opposite party. This cross examination is done by the opposite party. Now, in examination in chief, no leading question is allowed to asked. In examination in chief, no leading question is asked from the witness. Leading question means the question which owns its own answer. As you may say that these injuries are caused by sharp-edged weapon. You ask the person, are these injuries caused by sharp-edged weapon? Then it is a leading question. So direct question is that what type of weapon has been used, what type of weapon has caused these injuries. So as a person asked that who has inflicted these injuries, this is a normal question. Leading question which describes his own answer as Aslam has caused these injuries. आपको ये इंजरी असलम लगाई हैं, ये असलम ने लगाई हैं, ये leading question है. So no leading question is asked during examination in chief. During cross examination, which is done by the opposite party, jira, as a person describe as that you may appear before the court and you make the statement that when I came out of the college, I saw two person was in a state of fight, and then you describe all the story what you have seen before the court. Now, in cross examination, the lawyer of the opposite party, this is by the defense, lawyer of the opposite party will ask why you have gone out of college during when the lecture of the forensic medicine was on and you were wandering outside the college, why you have gone outside the college. This is the cross examination. So it is done by the opposite party. Then re-examination. In re-examination you will describe. During re-examination the doubts arises during cross-examination are cleared. During re-examination the doubts which arise during cross-examination are cleared. As you may say that you are not feeling well and you go out of the college to get some medicine from the POF medical store. So this is why you have gone out and you saw the incidents. This is the re-examination. कि मैं सर दर्द हो रही थी, मेरी तबीयत ठीक नहीं थी, दवाई लेने के लिए मैं बाहर निकला तो मेरे सामने ये देखा कि मैंने ये झगड़ा हो रहा है. This is re-examination. Documentary evidence की types. Documentary evidence, medical certificates, then medical legal certificates. Medical legal certificates may be post-mortem report, medical legal report and exhumation report. Medical legal report, post-mortem report, exhumation report. So there is also this dying deposition, and dying declaration is also a medical legal report. So dying deposition, dying declaration, it is also in some books it is a part of medical legal certificate, but in some books it is dying declaration is some other entity. We will discuss it later on, what is dying declaration and what is dying deposition. So in a documentary evidence key types, medical certificates, medical legal certificates and dying deposition and dying declaration. Medical certificates may be of physical fitness, whether the person is physically, medically mentally fit or not. Usually, these certificates are required after illness, as a illness certificate. After the illness certificate, this fitness certificate may be issued as a person will go get entry into a service. He will get the fitness certificate from a registered medical practitioner that the person is fit mentally and physically. Same way, a student before joining a college may be required to submit the fitness certificate from a medical officer stating that this person is physically and mentally fit. Then the medical certificate may be of illness, maybe of mental health, whether a person is fit mentally or not. It may be of age, it may be of death certificate. Medical legal reports. Medical legal reports, as you know, medical legal reports, postmortem report, and exhumation reports. So these are and other is the dying deposition and dying declaration. Circumstantial evidence, as you already know, to establish a conclusion by inference from the known facts. The facts from which an inference may be made is a circumstantial evidence. Now the important question of dying declaration and dying deposition. This is a university question very frequently asked during Viva. Dying declaration, it is a statement made by an injured dying person who is about to die. The statement made by injured dying person stating the circumstances leading to his death. So dying declaration is a statement given by a injured dying person stating the circumstances leading to his death is called the dying declaration. The requirement is the person should be injured and dying. There should be injuries and the person is dying. The doctor knows that the person is not going to survive. So in that case, he will arrange a dying declaration. The person should be injured, dying. Injuries may be caused by the weapons or injury may be caused by the poison, both the way. So the person should be injured and dying. He should actually die. He may not under the impression that he is going to die. No, the doctor will certify that the person is going to die. He will not survive. So in that case, a dying declaration is arranged by the doctor. So in case of natural death, as a person is dying with the heart attack, with the tuberculosis, or with any other disease, need not any dying declaration. This dying declaration is recorded in case this illegal violence should have been used. The person should be injured, dying. Injuries, mechanical injuries, or the injuries caused by poison, both the way. If a person is going to die with the tuberculosis, there is no need to record this dying declaration. So requirement, criminal violence should has been used. The person should be injured. Person should be injured. Injuries may be caused by the weapons, by the poison. So criminal violence should has been used. Requirement of dying declaration. The person should actually die. He may not under the impression that he is going to die. No, the doctor will certify that the person is actually going to die. Then third requirement is he should be compos mentis. He should be a mentally fit person. Before dying declaration, the doctor will certify that the person is in composed mental condition. He is a mentally fit person. Usually, the death which is caused by excessive bleeding, the patient retain its consciousness even at the end. आखिर तक जो बंदा है उसके होशो वास ठिकाने रहते हैं अगर उसकी एक्सेसिव ब्लीडिंग के साथ भी डेथ हो. सो इन ड्यूरिंग दैट period this dying declaration is recorded. So this dying declaration is recorded by may be recorded by any respectable person, and mostly it is the doctor. The person is brought to the hospital for treatment with the history of criminal violence, with the history of the injuries or use of poison. Now the doctor sees that the person is not going to survive. It is his legal duty that he should record his dying declaration, and usually the name of the person who has caused that injuries are these injuries also taken by the dying person. Usually it is asked that who has caused these injuries. And it is also supposed that the dying person will not tell a lie. It is also supposed that the dying person will not tell a lie. He will accurately tell the name of the person who has made these injuries. So it should be recorded in the presence of two witnesses. It should be recorded in presence of two witnesses. Witness may be staff nurse, may be LHV, maybe a dai, maybe a dispenser or any. It is recorded in presence of two uninterested witness जिनको इस केस के साथ कोई दिलचस्पी ना हो या पार्टी ना हो, तो उन दोनों की मौजूदगी में this is recorded. This dying declaration is recorded in question answer form. Doctor write down on the paper question and the person will give the answer. Usually name of the person who has caused this injury is taken by the dying person, and it is also supposed that the person who is dying will not tell a lie. Then at the end this statement is reread over to the patient. ये जो statement है ये उस जो अब मर रहा है बंदा उसको पढ़ के सुनाई जाती है. It is read over to the patient, उसको पढ़ के सुनाई जाती है, and at the end his signature or thumb impression is taken. At the end the signature of the person who is going to die is taken, or the thumb impression is taken, and it preferably the signature should be taken. Why? Because signature carries more values of signature of the dying person carries more values as compared to the thumb impression, because the thumb impression of the dead person may be taken. After death the thumb impression may be taken. So in this case the signature of the person carries more value, more medical legal value as compared to the thumb impression. So preferably signature are taken at the end. It is signed by the two witnesses and by the doctor and sealed and sent to the Alaka magistrate. This is the dying declaration. जो बंदा शदीद ज़ख्मी हालत में डॉक्टर के पास आया है, डॉक्टर ने देखा है कि उसको किसी ने मारा है और जो है उसके बचने के चांसेस कोई नहीं है, तो डॉक्टर उसकी डाइंग डेक्लरेशन बनाएगा. उसको सवालों जवाब के ज़रिए दो जो है गवाहों की मौजूदगी में सवालों जवाब पूछेगा, और उससे वो नाम ज़रूर पूछेगा कि ये इंजरीज़ किसने लगाई हैं. उसको वो से साइन लेगा. द पर्सन हु इज़ गोइंग टू डाई वो अपने सिग्नेचर करेगा. दैन दो विटनेस साइन करेंगे, डॉक्टर साइन करेगा, रिपोर्ट को सील करेगा, लिफाफे में डालेगा और इलाका मजिस्ट्रेट को भेज देगा. दिस इज़ द डाइंग डेक्लरेशन. Legal value, it carries less legal value as compared to dying deposition. It carries less legal value as compared to dying deposition. Procedure is the same. Two witnesses, a respectable person, usually doctor. Doctor will record in question answer form, and at the end, the signature of the person is taken, and this report is sealed and sent to the Ilaka magistrate. Then dying deposition. Deposition means statement under oath before the court. Deposition means statement under oath, हल्फ के साथ before the court is called the deposition. Statement under oath before the court is called the deposition. So dying deposition means it is the statement given by injured dying person on oath before the court in the presence of accused person or his liar, and the opportunity of cross examination is also provided to the accused person or his liar. This is the dying deposition. So dying deposition, here it is a statement given by a injured, again injured and dying person on oath. Person who is going to die will take the oath. On oath before the court. Now, how before the court? The person who is going to die cannot be shifted to Kachari for this taking the deposition. The Ilaka magistrate is called by the doctor. Doctor will call the Ilaka magistrate to please come to record the dying deposition of that person. So Ilaka magistrate is called. So it is the statement given by injured dying person on oath before the court, the court of magistrate, Ilaka magistrate, before court in the presence of accused or his liar. Accused or his liar. And opportunity of cross-examination is also provided to the liar or the accused person or his liar. This is the dying deposition. Requirements of recording the dying deposition. Dying declaration is recorded by usually the doctor or any respectable person, but usually the doctor certifies that the person is going to die, so the doctor will record the dying declaration, while this dying deposition is recorded by the court. It is before the court. It is on the oath. It is the presence of accused as his liar. Both presence of accused and his liar. So second is opportunity of cross examination is also provided to the accused and his liar. Any cross examination may be done by during this dying deposition. Then again the statement, this is recorded by the court, by the magistrate. It is reread over to the person who is going to die. Signature is taken, and then this court will take the statement, and the process will be over. Now, the one question is, how will you differentiate between dying deposition and dying declaration, or tabulate the difference between dying deposition and dying declaration? Now, as you know, dying declaration is recorded by any respectable person, or usually it is doctor, and dying declaration is recorded by the doctor or any respectable person. Dying deposition is recorded by the court. In dying declaration, the oath, the presence of accused and his liar is not necessary. There is no cross-examination in the dying declaration, but it should be in dying deposition. Now the question arises, what will be the legal value if the person survives? What will be the legal value of dying declaration, And what will be the legal value of dying deposition if a person survives? Now, suppose a person remains alive, he uh, did not die. Now, in that case, what will be the legal value? So, legal value, the dying declaration will carries no legal value. The dying declaration will carries no legal value if the person survives. Why? The dying deposition will carry its full legal value if the person survives, because the dying deposition is recorded by the court on the oath in the presence of accused as his liar. So इसको कहते हैं दफ़ा 164 का बयान, स्टेटमेंट अंडर सेक्शन 164. इसको दफ़ा 64 का जो 164 का जो बयान है, ये अदालत के सामने होता है, ओथ पे होता है, और इसमें जो है वो लायर भी होता है, और जो मुलज़म है वो भी मौजूद होता है, क्रॉस एग्जामिनेशन भी होता है. इसलिए इफ़ द पर्सन सर्वाइव, the dying declaration will retain its full value, while dying deposition will retain its full value if the person survives, and dying declaration will carry no value if the person survives, because the dying deposition is recorded by the court on the oath in presence of accused and his liar, and cross examination is also done. सारी कार्रवाई जो अदालत के सामने हुई है, इसलिए जो डाइंग डेपोजिशन है इसकी वैल्यू बरकरार रहेगी. अगर पर्सन बच जाता है, लेकिन डाइंग डेपोजिशन की तमाम वैल्यू बरकरार रहेगी अगर पर्सन बच जाता है, लेकिन डाइंग डेक्लेरेशन जो है इसकी कोई वैल्यू नहीं होगी अगर पर्सन बच जाता है. मेडिको लीगल सिस्टम्स इन द वर्ल्ड. This is a university question. Describe the medical legal system present in the world. Police system is police system is present in the subcontinent, in Pakistan, in India, in Bangladesh. In India, in city of Bombay, coroner system is there. Rest of in all of the India, it is the police system. Here, the police will decide whether a postmortem is required or not in a case. Then it will be decided by police, and usually the person of having not less than rank of ASI, Assistant Sub Inspector, he will decide whether a postmortem is required or not, or an exhumation is required or not. So it will be decided by the police. In Pakistan, this police system is present. So it is the police who will decide medico-legally that whether a postmortem examination is required or not, or whether an exhumation is required or not. It will be decided by the police, and then police will send the request to the doctor to perform the postmortem examination. Then coroner system, as you already know, this system is present in England and in Bombay city. Here a first class magistrate or a lawyer is appointed as coroner, and he will decide whether a postmortem is required or not, postmortem किया जाना चाहिए या ज़रूरत नहीं है, or an exhumation is required or not. It will be decided by a coroner in that system. So it is present in England and Bombay city of India. Then medical system, medical examiner system. We will discuss this continuity in the next. Medical examiner system is present in the America and Canada and in some countries of this North and South America. Medical examiner system. Here is a medical person, usually a forensic medicine expert or a forensic pathologist. He will decide whether a post-mortem examination is required or not, whether a exhumation is required or not. So medical person, he will decide. In medical examiner system, this system is present in America. This system is present also in Canada, in some countries of the South and this North America. This system is present. A forensic medicine expert or the forensic pathologist, he will be appointed as medical examiner and he will decide the case, medical, legal and post-mortem cases. Continental system is present. Number 3, continental system is present in Russia and in some other countries where around the Russia this system is present. And this system, some points are taken from police system, some from the coroner system and some from the medical examiner system. This is a mixed type of system which is present in Russia and states around the Russia. So police system is present in Pakistan, coroner system is present in England and in Mumbai city, continental system is present in Russia and the countries around the Russia, and medical examiner system is present mostly in the America, in the Canada, South and North American countries. So the question is, what is the best system, best medical legal system in the world? All system has some advantages, some disadvantages, but on the whole, the best system is the system adopted by the Americans as the medical examiner system. Medical examiner system is considered the best medical legal system of the world because here a medical person, a forensic medical expert or a forensic pathologist, he is a medical man, so he know much more as compared to the police, as compared to the coroner in first class magistrate or this lawyer. He know very much, he has got very wide knowledge about this post-mortem and other human anatomy, physiology and other sciences. He has got a very wide knowledge, so it is considered the best system. He will decide whether a post-mortem exhumation and everything is required or not. So medical examiner system is considered the best system in the best medical legal system in the world, and this is a university MCQ. Coroner system, as you already know, that this system is present in England. Here the coroner, so information from the police transferred to the coroner, information from the doctors and information from the public is transferred to the coroner, and then he will decide whether an autopsy, whether a medical legal examination or whether a exhumation is required or not. Next is the doctor before the court. Doctor in the witness box. This box is on the left side. So doctor, number 1, the doctor in the witness box. Doctor should, after noting down the summons, it is the legal duty of the doctor to attend the court. After serving the summons upon him, after noting down the summons, he should attend the court on a given date and time. And if he has any type of legal excuse that he may be become ill or he may be on an emergency duty on that day, so in that case he should inform well in time to the court that due to this and this reason he is not able to attend the court. Next is he should go to the court properly dressed. So please keep it in mind that the avoid to attend the court without lawful excuse is the contempt of court, and 6 months imprisonment may be awarded for the contempt of court. The doctor should be properly dressed, and also there should be white overall. Then go to the court, then ask the then report the reader that you doctor or you have come to the court, so that the time will not be wasted and your evidence may be recorded immediately. So go to the reader and please get it note please inform him that you have come. Next is during the cross examination, the question of your integrity and your personal character may also be asked by the lawyer of the opposite party. So don't lose the temperament. Don't lose the temperament. Any question may be asked by the lawyer of the opposite party. Never lose the temperament. The question, as you may be asked, you may be get an allegation from that you takes the bribe. डॉक्टर साहब आपने इतने पैसे इससे रिश्वत ली है, or the even the question relating to your personal character may be asked. That the lawyer may be said that you are a corrupt doctor, you are a mentally corrupt, you are a morally corrupt doctor, you are a financially corrupt doctor, you have taken so and so bribe from other person, you are a corrupt person. So in that case, don't lose the temperament. Never ever see to the liar. You should always address to the court. जज के साथ बात करें, वकील के साथ आप बात ना करें. Simply and in very normal way, you may say, no, this is wrong allegation. No, this is wrong. No, this is wrong. So don't lose the temperament. आपने बड़े ठंडे तरीके के साथ उनको डील करना है, उससे मुश्तिल नहीं होना. So any question regarding your qualification, regarding your experience, regarding your personal character may be asked during cross examination, and your foremost duty is avoid the contempt of court. आपने तौहीन अदालत से बचना है. तौहीन अदालत जो है, laughing in the court is a contempt of court. Then the newspaper reading before the court is also contempt of court. Then the using black glasses is also contempt of court. ये जो काले रंग की ऐनक जिसमें आंखें नज़र नहीं आती, अगर वो पहन के जाएंगे उसमें भी contempt of court लग सकती है. अगर when you avoid to attend the court before without any lawful excuse, it may also contempt of court. So and chewing pan, using chewing is also a contempt of court. So before the court, avoid to contempt of court. Sentences authorized by law. क्या क्या सज़ाएं कानून में दी जा सकती हैं? Death sentence. In some countries, this death sentence has been abolished, but it is still present in our country. And life imprisonment, umar qaid, then imprisonment 1 year, 2 year, 3 years, 7 years, 10 years. It may be simple or it may be rigorous. Rigorous means with labor. So सज़ा जो है वो बामशक्कत भी हो सकती है और बामशक्कत नहीं भी हो सकती. रिगोरस में ये है कि आपको कुछ लेबर वर्क करना पड़ता है जिसको सज़ा मिलती है. सो रिगरस इम्प्रिजनमेंट एंड सिंपल इम्प्रिजनमेंट. सिंपल इम्प्रिजनमेंट में कोई काम नहीं करना पड़ता, लेकिन रिगरस में आपको लेबर का काम करना पड़ता है. दैन फोर्थ पनिशमेंट इज़ 40 फीचर ऑफ प्रॉपर्टी. जायदाद की ज़ब्ती भी एक सज़ा है. सेंटेंसेस इट इज़ आल्सो ऑथोराइज्ड बाय लॉ. Fine is also जुर्माना is also a type of sentence which may be awarded. Whipping, कोड़े मारना is also it is a punishment which is present in the Islamic laws. Whipping, कोड़े मारना is also a punishment. amputation as in case of theft, चोरी के केसों में मुलज़म का जो लेफ्ट हैंड है वो काटा जाना, amputation, it is present in the hudud laws of this Islamic laws, hudud laws in hudud laws, cases of in case of theft, if it is proved, then the left hand of the thief is amputated. Then making equal injury, जितनी इंजरी जो है वो कल्परेट ने बनाई है उतनी ही इसको बनाई जाए. दिस इज़ कॉल्ड द किसास. किसास मीन्स टिट फॉर टैट, आई फॉर आई, नोज़ फॉर नोज़, ईयर फॉर ईयर. अगर किसी ने किसी की आंख निकाली है तो उसकी भी आंख निकाल दी जाए. दिस इज़ द किसास. एंड दियत इज़ कंपनसेशन. Diyat is compensation. So making equal injury is a qisas. This is a part of Islamic laws. Thank you very much. We will continue inshallah. Allah Hafiz.